Good afternoon, everybody. I'd like to thank you for joining us today for our webinar on the SECURE Act and spending bills, advice for plan sponsors and service providers. We'd like to thank you for joining us, and my name is Danae Delano. I'm a partner at the Wagner Law Group, and I'm here today with my partner, Dan Brandenburg, who is known by clients for his extensive experience and knowledge of pension and welfare benefit plans, executive compensation, including plans for tax-exempt organizations, and executive employment matters. He also has substantial experience with association-sponsored member service programs and represents clients regularly before the Internal Revenue Service, the U.S. Department of Labor, and the Pension Benefit Guaranty Corporation, or PBGC. I concentrate my practice in employee benefits law, executive compensation, and taxation, and counsel clients on all aspects of employee benefits design, implementation, termination, and compliance for retirement plans, health and welfare plans, and executive and incentive compensation arrangements. Today, this program is going to be the first in a series of webinars that we've decided to put on as a firm to educate you on the SECURE Act, which was enacted late last year. And this first webinar is going to concentrate on the provisions of the SECURE Act that are applicable to plan sponsors and service providers and our advice related to implementing those changes. So without further ado, I would like to turn it over to my partner, Dan, to kind of give you an overview of where we're going to go with the presentation today. Dan?
Thank you, Danae. One of the first things I want to talk about is the development of the pieces of legislation that we're going to be talking about. The SECURE Act was essentially developed last May as a standalone act. The legislative history, if you're going to look for legislative history, is mostly going back to May, although the legislative history may be a bit incomplete because there were slight changes made in the current act. There have also been some additional pieces, mostly in the non-pension area or non-401k area, which were added later that you'll find in different parts of the act. But the SECURE Act stands for Setting Every Community Up for Retirement Enhancement. It was enacted into law on December 20, 2019. One of the things you may notice is there's some very funky effective dates. There are effective dates, some going back before December 20, some being on December 20, some being within 10 days of December 20. And that's because there wasn't enough time between the time the legislation was introduced into the larger bill and the time that it was passed. It was basically over a long weekend that to change the effective dates to make them more rational. So presumably the IRS, to the extent the Labor Department is involved, the Department of Labor will provide us with more realistic deadlines. The other thing that I wanted to mention was that with regard to some of the provisions, there was a real issue with raising the revenue to cover the bill, and we'll talk about those later. You'll notice some very high increases in general fees. It's my understanding that those high general increases in fees were set up to enable the legislation to be revenue neutral. With that, Danae, do you want to pick up the first active slide on page 3?
Absolutely. Thanks, Dan. First, we are going to cover a mandatory change that's regarding part-time employee participation in 401k plans. Currently, plan sponsors can exclude part-time employees from participation in a 401k plan, provided that the part-time employees do not reach more than 1,000 hours of service in any 12-month eligibility computation period. Also, it may help to give a little plan design background here and explain that eligibility computation for 401k purposes can be based on hours of service, where an employer must track the hours of service worked during a selected 12-month eligibility period, or it can also be elapsed time-based, which means that hours are not tracked and instead an employee must have worked for a period of time, which once lapsed will result in his eligibility for the plan. Also something to note is that specific plan entry dates can also be utilized, which allow for participants to enter the plan only on specified dates once the eligibility requirements have been fulfilled. The SECURE Act change is attempting to allow more part-time employees to save for retirement and is a mandatory change. Service must be counted beginning in 2021, and consequently, the earliest time that part-time employees will have to be mandatorily included as participants is going to be the year 2024. The new rule requires part-time employees be eligible to participate once they have reached age 21 and worked at least 500 hours of service in 3 consecutive rolling 12-month periods. In addition, vesting service is required to be measured as a 12-month period during which an employee earns at least 500 hours of service. There is no requirement to provide any match or profit-sharing contribution to these part-time workers, and the mandatory rule does not apply to collectively bargained or union employees.
Shall I pick up today?
I didn't need you to. Did you have something you wanted to clarify?
Go ahead. Well,
So my advice for plan sponsors is that beginning in 2020, plan sponsors will need to begin tracking hours of service for part-time employees for both eligibility and vesting purposes. As early as 2024, you're going to have to allow certain part-time employees to participate in your 401k plans by making elective deferrals. As a result of this change, the 401k plan documents will need to be reviewed, and further guidance will need to be looked for when it's issued so that you can determine what you need to do to ensure compliance and administer the part-time employee participation. To the extent your document updates are necessary and amendments need to be made, participants will also need to be notified of the changes via a summary of material modifications or an updated summary plan description. As far as service providers are concerned, record keepers will need to take steps to ensure that they will be able to administer these special eligibility and vesting provisions for part-time workers, which are brand new, and could add complications, particularly for elapsed time plans and for transfers between part-time and full-time employees. Unless further guidance clarifies differently, only hours of service may be used for part-time employee eligibility and vesting purposes. Plans that currently employ the elapsed time method for counting eligibility service will likely have to consider whether they will use different service tracking methods or not, and if so, how employees who change from part-time to full-time status will be affected by their plan design decisions. Dan?
Yep, thank you, Danae. The next aspect is changes to Safe Harbor 401k plans. And the first item that we're going to talk about is the QACA changes. And for those of you who haven't worked with QACAs in a while, QACA stands for Qualified Automatic Contribution Arrangements. So essentially, it's one way that you can pre-program or push people into making minimum contributions. They can opt out, and the rationale is that inertia will take over and that people will then contribute much more money into the plan than they would otherwise contribute. So what are the changes? The current rule is that if you have auto enrollment that provides non-discrimination testing relief, and that QACAs have many additional compliance requirements, including that the maximum auto deferral for participants is 10%. We then go on what is the new rule. The intent of the new rule is to allow people to have higher contribution rates. So the new maximum on the auto deferral rate is 15%, except for participants' first-year participation, which still remains at 10%. The minimum thresholds of 3% to 6%, depending on the participation year, remain unchanged. So effectively, as I may have mentioned before, is that under the QACA aspect is automatic enrollment and pushes people to opt out rather than opt in, and the thought is that people will make greater contributions. A number of clients I work with have adopted the QACA rules on the thought that they're trying to increase people's retirement amounts, and especially if you're using 401k plans, the challenge is to make sure that people have enough retirement pay deferred with gains so that they can actually afford to retire. What's the effective date? The effective date is plan years beginning after December 31, 2019, but practically speaking for calendar year plans will mean the 2021 plan year. You may ask, help me understand what you just said. And again, if you go back to the comment I made earlier about the effective dates being the end of the year, it's highly unlikely that anyone would have been able to, between December 20th and December 31st, be able to put together the changes they needed to implement. There may be some, but highly unlikely. So as a practical matter, the first effective date is really the 2021 plan year. What's our advice to plan sponsors? We would advise to the extent possible that plan sponsors would adopt these changes, would want to adopt QACAs to begin with, but also adopt these changes so they get people to the maximum auto deferral rate. Consideration should include analysis regarding the effect on matching and other employee contributions, effectively talking about how much may this cost you if you increase the rates, and that the change would require change in enrollment, deferral, election change procedures, safe harbor notices, and updating plan documents, SPDs, and participation communications. If you'll notice, it will be a recurring theme about the requirement to make all these changes, both from a document standpoint and a procedural standpoint and an administrative standpoint, so that some of these changes, even though people may want to adopt earlier, may take a little bit of time for everyone to be able both to get used to the changes in the administration of them, but also more particularly to implement them within their own plan, so known employers. Plan sponsor advice. Plan sponsors must consider whether they can operationally support the plan. Considerations of whether or not they could support it include the effect on employer contributions, enrollment procedures, participant notices, processes for changing deferral elections, and document considerations. Additional guidance may also be forthcoming on mid-year changes in the application of uniformity requirement. Getting back to what we were talking about, some real possibilities on improving the auto enrollment, but it'll take some time and also get a sense of what you're getting into, you, the sponsors. Next item is non-elective safe harbor change. All safe harbor plans currently must provide a safe harbor plan notice to participants, with a special exception being made for non-elective safe harbor plans adopted by the 30th day before the close of the plan year if specific contingent and follow-up notices are provided. The employers can now adopt a non-elective safe harbor without traditional safe harbor notices. It can also be used for safe harbor contribution being adopted by a plan amendment by the 30th day before the close of the plan year, or if a 4% contribution is made for a plan year before the last day of distributing excess contributions for the plan year, generally the close of the following plan year. So effectively, it allows for post-plan year end changes. There are a number of those situations within this bill, which is very different, that it allows people to adopt plans till the time for filing the tax return, including extensions, a number of them like that. The effective date is plan years beginning after December 31, 2019, but as we mentioned earlier, practically speaking, we're talking about plan years starting with 2021. Next, what is our advice to plan sponsors? The existing non-elective safe harbor plan sponsors no longer have to have an annual safe harbor notice requirement, which for many people, even though it was an administrative requirement, would be a relief. It's one less thing to put on your calendar to make sure that it gets done and that there are no glitches along the way. For plan sponsors considering a safe harbor, this may be an option to retroactively adopt a safe harbor after testing has failed. That may be a significant benefit to certain folks. And what's our advice to plan service providers? Again, there'll have to be a lot of changes made to both the plan administration and the plan communication. To the extent that plan communication currently takes a back seat, plan communication, particularly in the first so many years, will become absolutely critical, both so that the sponsors, your clients, are familiar, and also so that the plan participants don't get left behind. The next change we're talking about is on page 9 of the outline, is in-service withdrawal for birth and adoption expenses, which is an optional change. It's not required. Currently, you can't take in-service withdrawal options for adoption or birth expenses. In the future, for both defined contributions and IRAs, participants can withdraw up to $5,000. It's permissible within 1 year following the birth or legal adoption of a child, and not subject to the 10% early withdrawal rule. One of the keys to be aware of is that these could be an interim loan, so that participants can repay their plans so that they don't wind up net behind. That's the good news. The bad news is make sure it's administered properly. It should be a challenge to make sure that those I mentioned do get administered properly. They're treated similar, the distribution is treated similar to hardship distributions and not eligible for rollover, but they're not subject to the mandatory 10% withholding but they are subject to a 10% withholding, mandatory 20%, but they are subject to 10% withholding unless the participant opts out. The effective date is distributions after December 31, 2019. And I'm sorry to repeat myself, but nonetheless, we're right now in February of 2020. I'm not sure how many people have really been able to focus and make those changes so that the effective dates may slip. What's our advice for plan sponsors? Plan sponsors may elect to add this feature. The details will be outlined in subsequent guidance. And even if a plan sponsor does not add the feature, a participant could be eligible for relief from the 10% penalty tax for early withdrawal. The change has a number of operational effects, including updating distribution forms, including 402F notices, plan documents, SPDs, participant communications, Form 1099-R reporting and withholding processes, and rollover processes. The technical side of it may wind up actually delaying the implementation of this, but as I mentioned earlier, this bill was added to a bill that would pass at the last minute, and the effective dates really haven't been changed. So just be aware. Service provider advice: changes will be necessary to distribution policies and procedures, related distribution forms, plan documents, SPDs, and participant communications. Disaster relief, we've had a number of those.
Just 1 second real quick before you go to disaster relief. I just wanted to make brief mention that there was recently limited guidance from the IRS through a draft version of the 2020 instructions for Forms 1099-R and Form 5498 for distributions from IRAs and employer retirement plans. And they're just draft instructions, so it's not definitive, but the IRS's approach in reporting such amounts is sometimes helpful. A withdrawal taken as a qualified birth or adoption distribution is reported on Form 1099-R based on the recipient's age. So for a recipient under age 59.5, you use Code 1, and the reporting entity makes no determination whether the distribution qualifies for the birth or adoption exception. That's the recipient's responsibility. The draft instructions further indicate that recontributions of qualified birth or adoption distributions to an IRA have to be reported on Form 5498 in Box 2, rollover contributions, for the tax year in which they're received. And even though we did get that limited guidance, there's a lot of questions that are left about these distributions. So questions like, must employer retirement plans offer such distributions to participants who are not otherwise eligible for an in-service distribution? What steps should plan administrators take when determining whether a distribution qualifies as a birth or adoption distribution? Is there a time limit for rollover into or repayment? So there are a lot of questions out there, and we anticipate additional guidance. All right, if you want to go ahead for disaster relief, Dan.
Well, thank you. I appreciate you're picking that up. Under the current rule, there had to be specific authorizations for disaster relief. Examples of Hurricane Maria, Harvey, Irma, a few others were Florence, the California wildlife fire victims, and hurricane for relief for Hurricanes Dorian and Michael. But in the future, the disaster relief contributions for 401k is allowed for more recent disasters. Participants have 180 days from the date of inaction to take advantage of the relief, which would make it June 17th, 2020. The effective date, again, is December 20, 2019. Give me a second. Their special plan amendments must be adopted by the end of the 2020 plan year, 2022 for governmental plans unless otherwise extended. Excuse me. Special provider advice. Review the process steps taken for prior disaster relief and adopt them for the new relief, including special employer election forms, distribution packages, rollover processes, loan processes, 1099-R reporting, plan document, SPD updates. Those, and I mentioned others before, but those items may not be totally inclusive. There may be others. Unless one is really pushed to adopt some of these changes, my suggestion is take a step back, make sure you get your implementation processes in order and then move forward. And I think, as I've mentioned before, and Danae may have mentioned, is that it's going to take some time for the administrators and other helping professionals to get their basic procedures together. For those people who need to be first, please go first. For those that may not have the greatest need to go first, it may make sense to sit back a little bit to get all of your service providers put together their processes and also get better guidance. Danae?
Thanks, Dan. So now I'm going to talk to you about lifetime income disclosures and investment options under the SECURE Act. These provisions are designed to grant participants more flexibility in being able to utilize and stretch their retirement income throughout the remainder of their lifetime to assist employees in having an income stream for their entire period of retirement. As the U.S. private retirement system has largely shifted away from traditional pension or defined benefit plans in favor of defined contribution or 401k type plans, there has been concern over whether participants' expectations of retirement security can adequately be met. Among these concerns are whether the defined contribution plan participants can accumulate sufficient plan savings to adequately fund their retirement living expenses, whether participants can afford to assume the mortality investment risk associated with managing sources of retirement income, and the kind of false illusion of wealth that can sometimes arise when you see a lump sum accumulated 401k account balance in isolation. About 10 years ago, the Department of Labor and the Treasury Department jointly solicited information on how the agencies might enhance, by regulation or otherwise, the retirement security of participants in employer-sponsored retirement plans by facilitating access to and the use of lifetime income or other arrangements designed to provide a lifetime stream of income after retirement. That request was very successful in spurring a great deal of public comment, but nothing was really done about it on a regulatory front. The SECURE Act, which includes 3 major lifetime income-related provisions, represents kind of a big step forward on the part of Congress to not only reduce some of the barriers that have traditionally discouraged the use of lifetime income products by defined contribution plans, but also to encourage participants to begin thinking about their defined contribution savings in terms of a lifetime income stream. Respectively, these provisions require the delivery of lifetime income illustrations to plan participants, allow for the portability of lifetime income benefits that have been accumulated in plan in connection with a change in providers, and provide a fiduciary safe harbor for the prudent selection of lifetime income providers. The first provision is mandatory and requires lifetime income disclosures be added to ERISA-required employee benefit plan statements. Such statements already require disclosure of a participant's account balance and the value of each investment option in an account. The SECURE Act will require, in addition to the current requirements, that monthly benefits be stated in form of annuity or joint and survivor annuity. There must be at least one benefit statement during each 12-month period that includes this information. And within 1 year of enactment, which would be by December 20th of this year, the DOL must prescribe permissible assumptions that can be used. They must issue model lifetime income disclosures and issue interim final rules. Because of that, the effective date is 12 months after the later of the issuance of those things that they're required to issue. So currently there's kind of a delayed effective date with regard to these income disclosures. So our advice to plan sponsors is to wait for the DOL guidance and discuss implementing the necessary changes with service providers. Service providers need to be a little bit more on top of this because record keepers and third-party administrators are going to need to change statements that are currently sent to participants. So you're going to need to consider your processes and procedures and technology that is available to do that. They'll need to determine when and how to implement the disclosures, but it will be virtually impossible to come up with set times and implementation until after the DOL issues the guidance that they're going to issue. So it's kind of a waiting pattern for that one. The next lifetime income disclosure and investment option is the portability of lifetime options, which is an optional provision that you can choose to implement. Currently, all of the applicable code sections to the different types of plans, which are listed on the slide, provide restrictions on when a distribution can be made from a tax-qualified defined contribution plan. The new rule allows the code sections are amended under the new rule to allow for the distribution of lifetime income investment that is a qualified distribution, or for the distribution of a lifetime income investment in the form of a qualified plan distribution annuity contract. The distribution event is tied to when the distribution option ceases to be made available under the plan, rather than when the other distribution events found in the code, like severance from employment, et cetera. The effective date of this optional change is already passed. It was December 31st of 2019. So this is an optional provision that you can consider at any time adding to your plan. If the plan allows it, a participant could take a distribution of a lifetime income investment in the form of a qualified plan distribution annuity if the lifetime income investment option is no longer authorized as an investment option under the plan, and distribution is made to another retirement plan or IRA through direct rollover or an annuity contract by direct distribution to an individual. So this actually is a pretty important provision and is really going to be seen in some of your 403B plans as a godsend, because it was hard to get these distributed before now, and this option could allow that. Other than that, I don't know that it will be as on the horizon type of option for an employer-sponsored, like just regular 401k plan, but it's definitely something to consider so that these types of options are going to be more portable. In terms of plan sponsor advice, if you already have lifetime income options, then that's a time to consider amendments to implement the additional distribution provisions so you can allow to distribute these type of options. Service providers, if they have plans with lifetime income options, there may be plan amendments and document updates and participant communications that have to be updated depending on whether a plan sponsor chooses to implement this type of option.
One of the things that we found in our practice that there are certain employers where the culture is to take annuities. There are other employers and plan sponsors where it's virtually impossible to have their employees take lifetime annuities. I know this has been a goal of the government for many, many years. There have been a number of proposals with limited success. Hopefully this one will be more successful because it is key to providing for adequate income for people into their retirement years. Danae?
Correct. Thanks, Dan. The final and third lifetime income disclosure and investment option provision of the Secure Act is the fiduciary safe harbor for selection of lifetime income providers. This is also an option that plan sponsors can take advantage of. And basically, the Secure Act has enacted a whole new section of ERISA, Section 404E, which is a new optional safe harbor for the prudent selection of a guaranteed retirement income contract on behalf of an individual account plan. The term guaranteed retirement income contract is defined very broadly to include both payout products and products providing for the accumulation of retirement income guarantees on an in-plan basis. This type of contract is an annuity contract for a fixed term or a contract which provides guaranteed benefits annually or possibly more frequently for at least the remainder of the life of the participant or the joint lives of the participant and the participant's designated beneficiary as part of an individual account plan. The provisions of the new safe harbor have their origins in and are derived from the pre-existing regulatory safe harbor for the selection of individual account plan benefit distribution providers, which was adopted by the DOL in 2008. So I'm kind of call it the 2008 safe harbor, which describes a series of steps for a plan fiduciary to engage in when they're prudently selecting a benefit distribution annuity provider for an individual account plan. Under the 2008 safe harbor, a fiduciary had to engage in objective, thorough, and analytical research to select a provider. They had to appropriately consider information sufficient to assess the ability of the annuity provider to make future payments under the contract. They had to appropriately consider the cost, including fees and commissions, of the annuity contract in relation to the benefits and administrative services that were provided. And they had to appropriately conclude that at the time of selection, the annuity provider is financially able to make all future payments and that the cost of the contract is reasonable in relation to the benefits and services that are provided. And if necessary, consult with appropriate experts for purposes of compliance with those above provisions. The 2008 safe harbor also included a provision explaining the phrase time of selection, which is used in requirement 4. In its adopting release, the DOL explained that a number of commenters had expressed concern that plan fiduciaries would need to comply with the safe harbor conditions where a plan might utilize the product's asset accumulation features even though the plan might not annuitize benefits under the arrangement. And the DOL clarified here that the safe harbor conditions applied only to the decision to purchase a distribution annuity. For that reason, the time of selection is defined to mean either the time that the annuity provider and contract were selected for purposes of contemporaneously distributing benefits to a specific participant or beneficiary, or the time that the annuity provider is selected to provide annuity contracts at future dates to participants or beneficiaries, provided that the selecting fiduciary periodically reviews the continuing appropriateness of their conclusion that the provider is financially able to make all future payments under the contract. Over the past few years, many plan fiduciaries have expressed extreme discomfort about relying on the safe harbor in the 2008 safe harbor. In large measure, that discomfort stemmed from the vague wording that were in the conditions, and fiduciaries were concerned that given those subjectively worded standards, they couldn't confidently conclude that the conditions had been satisfied. So given the lengthy duration of payout under an annuity contract, like 30 years, a lot of plan fiduciaries were concerned about the potential for claims for fiduciary breach and resulting liability if they utilized the safe harbor and ultimately a provider that appeared financially sound would not be able to make good under the contract. So the new safe harbor is designed to address these concerns. It also expands the scope of available safe harbor relief to include not only the selection of benefit distribution providers, but also the providers of products that allow for the accumulation of retirement income guarantees on an in-plan basis. So to make the safe harbor easier to rely on, the new law modifies several of the conditions of the 2008 safe harbor, dispenses with certain others, and also facilitates satisfaction of conditions related to assessing the insurer's financial strength by deeming those conditions to have been met where the insurer delivers certain written representations to the fiduciary. So it's easier to rely on, and you can rely on written representations of the insurer. I think the most significant feature of the new safe harbor is the provision that deems the selecting fiduciary to have satisfied the conditions related to the adequacy of the insurer's financial capabilities on these written representations from the insurer. Subject to the caveat that after receiving those representations, the fiduciary also must not have been given notice of any change to their circumstances that would make them think that the representations were false. But the insurer can give the representations to the fiduciary that they are licensed to offer the contracts, that at the time of selection and for each of the immediately preceding 7 years, they've operated under a certificate of authority with the insurance commissioner of the state in which it operates, that hasn't been revoked or suspended, that it's filed the required audited financial statements in accordance with the law in which it's operating. It maintains and has maintained reserves which satisfy all statutory requirements of all states in which they do business, and it's not operating under any orders of suspension, rehabilitation, or liquidation. They can also give this certification that at least every 5 years a financial examination by the insurance commissioner in the state in which it's set up is undergone, and that they will notify the fiduciary of any change in circumstances after providing those representations if it is material. So that is the biggest thing, I think, with regard to the new safe harbor under the Secure Act. But finally, for any avoidance of doubt, the new safe harbor provides that where a plan fiduciary satisfies its conditions, it's relieved of all liability for any losses that may result due to an insurer's inability to satisfy their financial obligations. So it really gives the safe harbor some teeth as well. So what is our advice to plan sponsors and service providers? Plan fiduciaries can consider utilizing the safe harbor. It has a lot more teeth. You can rely on it. It's not as vague. It's much easier than the current DOL guidance that exists. The financial wherewithal of the insurance company only needs to be examined at the time of selection, and representations can be relied upon. As far as service providers are concerned, insurance companies are probably going to start advocating lifetime income options for defined contribution plans, even though that has not been the norm, although like Dan said, there are some of our clients where there's kind of a culture associated with that where they are already offered. A fiduciary has to make a prudent selection but can rely on the written representations from insurers. There's no duty to monitor anymore, so this is kind of a big relief. The next thing I'm going to talk about are lifetime and post-death required minimum distributions under the Secure Act. The Secure Act makes major changes to the rules requiring mandatory minimum distributions that are required to be taken from retirement plan accounts following the later of the attainment of age 70 and a half or termination of employment. To reflect increased life expectancies and fortify retirement savings, the Secure Act increases the age at which individuals must start distributing retirement plan assets to 72 from 70 and a half. Notably, the age of 70 and a half was established for account owners to begin taking distributions from retirement plans almost 60 years ago, and this age has never been adjusted to take into account increases in life expectancy. But before we get into any details, I think it's kind of helpful to review how a required minimum distribution works, or an RMD. Owners of retirement accounts must begin taking withdrawals upon reaching a certain age, regardless of whether they need or want the income. Simply not taking a distribution is not prudent. Not taking or taking less than the full required minimum distribution subjects the account owner to a hefty 50% penalty tax on the amount that was supposed to be taken but wasn't. For example, if you missed your 2019 required minimum distribution of $20,000, you would owe the IRS $10,000. That's a big penalty. Under the new law, the required beginning date for required minimum distributions is moved to age 72 from age 70 and a half, effective for individuals who reach age 70 and a half after December 31st, 2019. Therefore, the timing of the initial required minimum distribution will now be age 72, not 70 and a half. In the new law, required minimum distributions for qualified retirement plans generally must commence by the later of April 1st of the calendar year following the calendar year in which an employee attains age 72, or the calendar year in which the employee retires, known as the required beginning date. The required beginning date for certain 5% business owners is April 1st following the year in which they attain age 72, even if they continue to work for the employer sponsoring their retirement plan. The rule is similar for IRAs, excluding Roth. The required beginning date is April 1st of the calendar year after attaining age 72. The increased required minimum distribution age is in addition to IRS proposed changes in the required minimum distribution life expectancy tables beginning in 2021. Both changes will allow your nest egg to bake a little longer before you have to take the required withdrawal. So you can keep your money in there a little bit longer before you have to take it out. What if you attained age 70 and a half during 2019? Does the new increased required minimum distribution age mean that those individuals can delay their required minimum distributions? Unfortunately, no. The Secure Act changes the age for participants who attain age 70 and a half after December 31st, 2019. Therefore, IRA owners, including simple IRAs, 5% or more business owners, and retirees who turned 70 and a half during 2019 will still be required to take their minimum distributions by April 1st, 2020. Because the Secure Act became law so late in 2019, some organizations have struggled to accommodate the new rules. So some of the service providers and plan sponsors may have told, well, service providers for IRAs, but plan sponsors may have done it as well, that turning 70 and a half in 2020 would require a minimum distribution in 2020. But that's incorrect, since it would be required at age 72 instead. Fortunately, we've had some very recent guidance in IRS Notice 2020-6, which grants relief from sanctions that could be assessed for the reporting inaccuracy, provided that if by April 15th of this year, IRA owners and retirees are notified if they've already received accurate information or inaccurate information, that no 2020 required minimum distribution is required. So they should ensure that the 2019 Form 5498 for IRA owners is filed with the IRS by June 1st, 2020. Excuse me, does not have a check mark in the box 11, so which indicates that a required minimum distribution is required for 2020. So that's some relief for IRA owners, and there's more guidance being considered by the IRS. As far as plan sponsor advice, plan sponsors should review their required minimum distribution processes and procedures, discuss the same with the service providers to ensure compliance, which now will require tracking two separate rules, and that change will require modifications to distribution forms, plan documents, SPDs, participant communications, and 402F notices. Again, this is a mandatory change, so that's something that you're going to want to take a look at fairly soon. The second lifetime and post-death required minimum distribution provision under the Secure Act is the acceleration of post-death required minimum distributions. This is also mandatory. Currently, distributions have to be paid out following the death of the participant in accordance with the plan terms, but no later than when mandated by Code Section 401A9. The rules vary if a participant dies before or after they reach their required beginning date, but in general, they permit distributions to be paid over a beneficiary's life expectancy. The new rule is that for defined contribution plans and IRAs, distributions after the death of the participant generally must be made by the end of the 10th calendar year following the year of death. This used to be 5 years. However, payments can be made over the beneficiary's life expectancy if the beneficiary is a surviving spouse, a disabled or chronically ill individual, or certain trust for the same, a beneficiary no more than 10 years younger than the participant, or a minor child of the participant, generally until the child reaches the age of majority. Non-designated beneficiaries are still subject to the prior rules, which would require payment out over 5 years instead of 10. The effective date for this provision is for any death.
Let me just, if I may just interject for a moment. One of the things that we're going to be picking up is we're going to have later on in the next month or two, we're going to have another program that's going to be dedicated to estate planning only. So there'll be a little bit more focus about the specifics. If those of you who are listening are heavily involved in estate planning, there'll also be discussions in a later program with regard to the implications for estate planning. I mean, the biggest change on this is the elimination of what's been called a stretch IRA. So if in the past, very often, people would leave an IRA over the remainder of a child's lifetime, so that you could have an individual getting the payout of an IRA over the next 40 or 50 years. That's been stopped. I mean, part of it, I think, is a question of raising revenue to pay for this bill. Part of it, I think, is also people felt, hey, it wasn't quite right to have to be able to delay a pension distribution for a very long, extended period of time. Let me let you pick up. I'm sorry.
Right. Yeah, absolutely, Dan. That's a very good point to make. And so, you know, our advice to plan sponsors are you should review your plan terms and your required minimum distribution processes and procedures. We anticipate additional guidance because of the complexity of these rules. Like Dan said, there's also a lot of interplay between the rules and estate planning issues. So those are things that kind of have to be in your mind when you're deciding how to communicate with participants regarding the rules. As far as service providers go, they're going to have to operationally determine the process of required minimum distributions and then also update all the documents, et cetera. So basically what we're talking about here is the Secure Act eliminates the ability to make annual minimum distributions over the life expectancy of a designated beneficiary following the death of a participant unless the beneficiary is the participant's spouse, child under the age of majority, and all the other things that I said before that are listed on the slide. And the alternative minimum distribution period is extended to the end of the 10th year following death, regardless of whether the participant died before or after minimum distributions began. So it's a major change in the rules. It's something that you're going to definitely have to get used to. And with that, I'm going to turn it over to Dan to talk about our next topic.
Okay. This is probably one of the most difficult provisions, not necessarily difficult conceptually, but really sort of applying it and dealing with it. One of the things that I understood, I asked some questions of people involved in the legislative process, why all these huge increases? This seems to be beyond the pale, and without responding to my beyond the pale question, they basically said, we had to pay for it somehow. And if I understand correctly, and if the response to me wasn't half tongue-in-cheek, that the main driver to this was how are they going to pay to all these revenue losers in the rest of the bill? And the answer was, well, we're going to put a huge increase on civil penalty changes. You can take a look at our outline with the specific penalties currently. The big challenge, though, is really we're looking at I'm looking for a page number. The page in the outline that picks up under Form 5500 civil penalty changes, mandatory changes, so that the Secure Act actually increases the penalties by roughly tenfold for most of the penalties in connection with failing to file an annual report for a qualified retirement plan. Under the new plan, penalties imposed under the code in connection with filing the annual report for a retirement plan can amount to $250 a day, up to a maximum of $150,000 per annual report. If you do the math, 250 times 300, I think, comes out to be well in excess of, well in excess of $60,000 a year. I mean, the numbers are huge, up to a maximum of $150,000 per annual report. There's a separate civil penalty imposed under ERISA in connection with failing to file Form 5500, which has not been changed. There is an annual cost of living increase on the ERISA civil penalty for Form 5500. One of the things that really has been a challenge on this, in my mind, is, again, what happens if you have an inadvertent mistake? I mean, we've been involved over the years in trying to correct some of these failures to file forms for long periods of time, and essentially we've generally been able to compromise them at relatively low fees. In this case, though, the fees are great, and will the respective agencies say, hey, it's on the books, it's meant to be solely for bad actors, or will they wind up taking these penalties literally? And what is the lesson to be learned is that no longer are filings an afterthought, that they really need to be a top-of-the-mind thought about filing these forms and filing them timely. The last piece is there's a new penalty for failing to file an initial registration statement that amounts to $10 per participant per day, up to a maximum of $50,000. Failing to file an update can result in a penalty of $10 per day participant, up to a maximum of $10,000. I mean, huge increases. What's the effective date? Penalty amounts apply to returns and statements required to be filed after December 31, 2019. It's not entirely clear to me whether or not that penalty is for the 2019 year. Is it for earlier years? So if you have a fiscal year, would that penalty kick in sometime early this year? I mean, I don't think we really have clear advice as to that. What's advice for plan sponsors and service providers? Plan sponsors should keep in mind that failures to satisfy annual reporting requirements for retirement plans carry the potential for substantial monetary penalties under both ERISA and the code. Historically, the DOL has been a lot more vigorous in their enforcement program than the IRS. My thoughts are that we may find that the IRS increases its enforcement program on these penalties. That should be the biggest challenge, is to see whether or not these numbers are markers, whether or not the procedure is set up for forgiving these penalties, or whether these penalties really become real. And I'm emphasizing these penalties because often people forget to file their forms, not maliciously, not even carelessly, but it just falls in between the cracks. So we're going to have to take a wait and see how serious the government is about enforcing the penalties. And if they're serious, these are going to have to be top of the mind aspects, not after the fact. Also, historically, there have been fairly generous forgiveness rules. Will those continue or not? We can only wait and see on those. Changes affecting defined benefit plans. This is a big one here. And it only affects a limited number of people, but quite a few people wound up having frozen DB plans, and they allow those frozen DB plans to run out. And what happens very often is either that individuals in these frozen plans who were highly paid wind up staying longer than the rank and file, or many of the rank and file over the period of time would become highly compensated. So many of these plans wound up with being very top heavy and having problems with compliance and the like. In the past, there's been relief provided on an ad hoc basis, on a ad hoc but nonetheless regular basis. The effective date is for plan years after December 31st, 2019. One of the thoughts being on the advice to plan sponsors of frozen DB plans should consult actuaries and legal counsel regarding implementing the change, and the service provider advices include relief and testing and consider the impact on pending corrections and future design changes. So that for those people who are affected by these are very critical changes. They're ones that may not affect most of us, but for those who are affected by them, they're very critical. The next item is in-service distributions allowed at age 59 and a half. The current rules are generally more stringent, but these would allow in-service distributions from a pension or money purchase pension plan and a 457B plan at 59 and a half. 401k plans already have fairly liberal requirements for distributions. The other plans have had much stricter provisions, but these would allow for in-service distributions at 59 and a half, which for those people who are affected may be critical. What's our advice to plan sponsors? That plan sponsors of money purchase plans, 457B plans, and pension plans may consider allowing in-service distributions of 59 and a half. Those may be very critical. One of the things that it's not necessarily a pension-related aspect, but allowing people to phase out and phase back during their later employment years has become an important human resource aspect. Some of it with regard to benefiting the employees. Part of it's also to preserving those long-term employees' knowledge base. So they often are the key knowledge base for the employer, and many employers would like them to continue their employment for some period of time after their retirement date, but nonetheless, the issue has become, can people afford it? And anyway, that's the purpose for this change. Service provider advice: if in-service distributions are allowed at age 59 and a half, documents ought to be updated, including SVDs, distribution forms, and operationally processed. And one of the issues here is in terms of service providers, there have been numerous various service providers that have been involved in these, both enforcement, operational compliance, and record-keeping compliance. And often those service providers and their roles wind up blending or bleeding over to different people. And so anyway, so that the service providers really need to take a careful look at what their responsibilities are and make sure that they're looking at what the timelines and the additional responsibilities they may have, or the additional leniencies that they may have. So maybe more than just lawyers worrying about the legal side and record keepers worrying about the record keeping side. I think everybody needs to be familiar with all these provisions and changes. Janae, you want to pick up the next slide?
Finally, we're going to briefly touch. Finally, we're going to briefly touch on some Secure Act changes applicable to health and welfare arrangements. First, the PCORI fees that were originally enacted to fund the Patient-Centered Outcomes Research Institute, which was implemented under the ACA, have been extended now. The PCORI fees applied to plan sponsors of self-funded health plans and insurers, and they're based on the number of covered lives under the plans. They've been required for the last 7 years, with the last fee being due July 31st of 2019. This means now under the Secure Act, the fee will apply to plans with calendar year plans that end on December 31st, 2019, and that fee payment will be due by July 31st of 2020. Note that there's some question regarding the fees application to plan years that ended between October 1st, 2019 and December 19th, 2019, which we have a lot in those few months because of the ACA, but we expect that the IRS will clarify this in guidance that will be forthcoming. Plan sponsors of self-insured plans should be prepared to file the Form 720 and pay the 2019 fee by July 31st of this year. Plan sponsors of insured plans don't owe the fee, but you could see your health premiums increase as insurers look to recoup the fee that they have to pay. The IRS hasn't issued the 2019 fee amount, but we expect them to do so in the very near future. The next item is the paid family leave tax credit has also been extended. Again, this is a tax credit that was scheduled to end in 2019. The credit is extended for 1 year in 2020 and is a business tax credit for certain employer-paid family and medical leave ranging from 12.5% to 25% of wages paid qualifying employees for 2 to 12 weeks of leave annually if wage payments were at least 50% of normal wages. Most employers didn't take advantage of these credits because it would have required significant changes to their leave program, and it was temporary. It was just a 2-year tax credit. Those employers should analyze their leave programs and make sure they don't want to make changes to take advantage of this in 2020. But employers that did qualify and did take the tax credit in 2018 and 2019 likely can continue to do so in 2020. The next change doesn't probably require much explanation because everybody knows what it is, but the Cadillac tax has finally been repealed. This provision repealed the much maligned section of the ACA that would have imposed an excise tax on high-cost employer health plans that was widely referred to as the Cadillac tax. It was scheduled originally under the ACA to be implemented in 2018. It had been delayed to 2022 and now has been canceled altogether. So sponsors of high-cost employer health plans and union health plans no longer have to worry about the Cadillac tax penalty. It's gone, and it's for good, not just until, it hasn't just been delayed, now it's gone for good. The final item that affects health and welfare plans is the unrelated business income tax on qualified transportation fringes has been repealed. This actually repeals this provision retroactively, so like it never existed. This provision of the code, which is Code Section 512A7, subjected employers that were tax-exempt organizations to an increase in their unrelated business taxable income by the value of qualified transportation fringe benefits, including any parking facilities used in connection with qualified parking benefits that were provided to their employees. So it's only applicable to tax-exempt organizations, and they no longer have to add the value of these things into their unrelated business income tax. So it's a big deal. Going forward, they don't have to include it, and because it was retroactively repealed, any employers that included those amounts in their UBTI in prior years' returns should consider filing amended forms 99T, 990T to claim a refund. And just as an interesting aside, my partner Dan, who's been on this call with me, was involved with the American Society of Association Executives, which was among the leaders of the coalition that was responsible for introducing and getting this change actually implemented. So congratulations, Dan, and that's kind of interesting to me.
Well, thank you.
So that concludes our presentation, but in sum, I just wanted to provide a couple of comments about the provisions of the Secure Act being a very kind of eclectic hodgepodge of ideas that have been floating around in the industry that have now been consolidated and enacted, many with almost immediate effective dates. However, the craziness of the effective dates and the hodgepodge nature of the provisions, including that some are mandatory and some optional, makes it vital for plan sponsors and service providers to educate themselves about these provisions immediately and prioritize which are impactful and which to consider for optional plan design changes. Note that one section included in the Secure Act offers a remedial amendment period. That allows plan sponsors to make changes immediately in an operational sense, but they have until the end of the 2022 plan year to adopt an amendment. This will mostly apply to the provisions that are optional and not required. Amendments for any required modifications are not required to be incorporated into the plan document until the modification shows on the cumulative list from the IRS, at which time the IRS will provide the date by which those amendments have to be adopted. As service providers address any changes to their systems to comply with the law, plan sponsors can expect to be kind of getting hit up with education from them and from programs like this about the provisions of the Secure Act and how they could possibly impact their plans. Plan sponsors will be informed of additional features they may consider for plan design, as well as what kind of documentation and amendments would need to be made to implement those changes. Thank you so much for attending our webinar today. If you have any questions at all or would like a copy of the presentation, please contact me, Dan, or any other Wagner Law Group attorney. Again, thank you so much for listening.
Bye now.